Hello everyone, my name is David Pulio and I'm with Foley & Lardner's marketing department. On behalf of Foley, I'd like to thank you for participating in our Staying Competitive and Compliant in the EU web conference series. At this time, all participants are enabled in listen-only mode, and as a reminder, today's web conference is being recorded. Before we begin, we have just a few housekeeping announcements that we'd like to run through. Today's program will last approximately 1 hour, followed by a short question and answer session. We would encourage all of our participants to submit written questions during the program. You may type your question into the Q&A widget open at the left-hand side of your screen, and we will respond to questions at the end of the program, time permitting. The webcast console that you're looking at can be completely customized, and you can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon, or by clicking on the On24 support team link in the resource list to the left side of the presentation window. The PowerPoint presentation will be available on our website at Foley.com within the next few days, and you may also find a copy of the slides in the resource list widget also on the left side of your screen. As a reminder, this will be recorded, and the recording of this event will be available at Foley.com as well. Foley will apply for CLE credit for this web conference. If you did not supply your CLE information upon registration, please send an email to myself at dpulio@foley.com. To be eligible for CLE, you will need to log in to this session and answer a polling question during the program. So if you are on a phone line, please log in to the actual web portion of the conference. As a final note, those seeking Kansas, New Jersey, and New York CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 4-digit code will be announced. Please email the form with the code included, again, to myself at dpulio@foley.com. Now I will turn it over to our speakers for today's presentation, Howard Fote and Sophie Lignier. Howard, you may begin.
Thank you, David, very much. Good day to everyone. This is the 8th in a series of annual webinars presented by Foley and Lardner on important competition issues posed for companies doing business in the EU. As the title indicates, it's intended to provide a review of important developments during 2014 and to make some predictions for priorities in 2015. The prior presentations have focused on a wide variety of topics. In the main, we have discussed a number of times the creation and evolution of the EU from 6 member states in 1957 to 28 member states today. It's the largest free trade zone in the world, administered by EU centralized institutions, the Council, the Commission, and the Parliament, in conjunction and coordination with the EU member states. We focused on a wide variety of substantive and procedural legal issues, including merger control, competition laws and procedures, in particular vertical restraints, technology transfer developments, cartel enforcement, competitor collaborations, trends and developments in European Community competition law, merger enforcement, and other important issues. As David indicated, the text of this webinar will be posted on the Foley website. During our presentation today, Sophie and I will cover a wide variety of topics that are pertinent to 2014 developments and 2015 prospects. There was this fall a new commission and commission elected and a new commissioner for competition. We're going to be talking about price signaling, cartel enforcement, an important European Court of Justice decision on the scope and application of Article 101, the new technology transfer block exemption, exclusive rebates that may be unlawful unless objectively justified, EU merger developments, vertical restraints, importantly, the arrival at last of private damage actions and the possibility of collective redress, as well as 2015 prospects. As has been the case in all of our webinars, we have tried to provide some useful basic background information about competition enforcement in the EU. There is a website, ec.europa.eu/competition, which contains a multitude of source material that should be your reference point for questions and answers to those questions. The focus of our discussion today will both involve an analysis of the structure and the process of those competition structures. We're going to talk a good bit about the cooperation between the EU and its member states, or in some instances, the lack of cooperation between the EU and its member states. It is important to understand the legislative process that creates these competition law provisions. There has been an evolution to greater responsibility on the part of the European Parliament as the EU has grown and matured. There are a wide variety of EU legal materials, including regulations, decisions, directives, notices, and guidelines. Each one has a special and unique and well-defined role in the competition process. As I indicated, there is a devolution toward greater responsibility and greater resources for national competition authorities and national courts, particularly in the area of vertical restraints, as the Commission seeks to focus its attention on European-wide issues, particularly mergers and cartel enforcements. Finally, we're going to touch briefly on the so-called de minimis notice. That is a wake-up call for all of us who practice in the EU in terms of its important underscoring of the very small kinds of restraints that can trigger EU enforcement. I'm going to turn it over now to Sophie for a discussion of the new Commission. Sophie?
Thank you, Howard. Yes, since November 1st of last year, we have a new European Commission, a team of 28 commissioners, one from each EU member states, appointed for 5 years, and they are led by the Commission President Jean-Claude Juncker from Luxembourg. The new competition commissioner is Margaret Vestager. She's Danish, and for the first time commissioner. What I can say about her is that she's maybe unlike her predecessor, she's not a vice president of the Commission. In this new Commission, competition remains outside any clusters and the standard portfolio. But she's, as Almunia and the other predecessors, Monti and Nelly Cruz, an economist and well-known politician in her home country, Denmark, where she was the former Deputy Prime Minister and Minister for Economic Affairs. She has also direct business experience, held a number of company board positions, and by reputation she's known as being a tough negotiator, unlikely she's likely to resist the pressure from political interference on antitrust decisions. And important point is that she has appointed as a chef de cabinet Dityo Jorgensen, who has more than 20 years of experience in EU institutions in a wide range of economic positions. And this new commissioner is going to inherit a number of high-profile cartel and antitrust investigations such as Gazprom, but also the Google's investigation. And in that respect, she said recently that she wants to understand the views of those who directly affected that are affected by Google's business practices. And considering the complexity of the issues, she will need some time to decide on the next step. The new commissioner is going to have to deal as well with a kind of new type of investigations relating to horizontal coordination through price signaling. It consists of exchange of information made in the form of public unilateral announcement, and as such, making a unilateral announcement does not constitute a concerted practice within the meaning of Article 101 of the treaty, but it may amount to concerted practice when such public announcements involve an invitation to collude or are followed by public announcement made by other competitors. This issue was first assessed a few years ago in the Rupert case. The companies in this case had set up a system of quarterly announcements, which the Commission viewed as an indirect exchange of information on future market conduct. And what decision was overturned by the court, which said at the time that each company engaged in this announcement, and therefore it could not be sure of the conduct of the others. Despite so, the Commission was not approach was not returned by the court. It shows that public unilateral announcement could still amount to a concerted practice when followed by public announcement by other competitors. So therefore, the Commission remains concerned about the strategic responses of competitors to each other's public announcement, and that could allow competitors to reach a common understanding about the terms of coordination. And the Commission is actually currently pursuing a case where public announcement by one company were followed by the public announcement made by competitors in this investigation that was launched 1 year ago against a number of container shipping lines. The Commission is considering whether by making regular public announcement of general rate increases through press releases and on their website or also through the truck press, whether the shipping companies engaged in information exchange that amounted to an illegal concerted practice. So accordingly, companies should consider very carefully before making public statements, particularly about future prices or output, and think whether their announcement could be construed as an invitation to collude. I'll pass it up now to Howard.
Thank you, Sophie. As a natural flowing from that discussion of horizontal coordination is the important and high priority topic of cartels. In 2014, fines levied against 10 cartels in widely divergent industries, in particular in the auto parts industry, which we will talk about later. Total fines exceeded 1.6 billion euros in 2014, compared to 1.8 billion euros in 2013 and 1.8 billion euros in 2012. Over the last 5 years, almost 9 billion euros in cartel fines have been levied. The small decline in 2014 cartel fines should in no respect be viewed as an indication of reduced priority. As the outgoing commissioner indicated in his final remarks on September 19, there is a long list of ongoing cartel investigations in the automotive sector alone, involving airbags, safety belts, steering wheels, cooling and lighting systems. The global auto parts probe continues to provide fertile enforcement ground in the EU and underscores the absolute necessity of firms to adopt effective compliance programs. If you go to the EU Commission website, which I cited earlier, there is a detailed compliance program outline that you can examine and perhaps adapt for your particular company's needs. The engine of EU cartel enforcement, as is the case in the United States and elsewhere, is increasingly driven by leniency and leniency plus proceedings that act as a catalyst for enforcement activity. There is in the EU, as in the United States, great pressure to be first in line to disclose a cartel with concomitant reduced penalties, or in the case of leniency plus, to disclose a different cartel and perhaps escape penalty for that cartel as well. Cartel settlement procedures act as well as powerful incentives to avoid costs and risks, and indeed as a disincentive to exercise your rights to contest the charges. Importantly, it is essential that you understand that the Commission acts as the prosecutor, the judge, arbiter of disputes, and the jury, making decisions on the outcome of these proceedings. In a discussion just yesterday, a number of noted EU practitioners said that they felt that this administrative system was deeply flawed and was not rendering decisions that were as thoroughly adjudicated and as fairly assessed as would be the case in other jurisdictions where there is an adversary process and where the decider of the facts is not the prosecutor and the judge, as well as the jury. I would suggest that while this is a view that is widely held, it's nevertheless one in which the status quo is likely to be maintained, if not the Commission getting additional power as important decisions during 2014 on investigative procedures, dawn raids, and access to file make clear. Having said that, there was an important development during 2014 relative to the standards that must be used in terms of determining whether a violation of Article 101 has occurred. Article 101 is similar to Section 1 of the Sherman Act. The Sherman Act, like Article 101, proscribes concerted actions in certain specific kinds of situations. Article 101 says that those restrictive practices which may affect trade between member states and which have as their object or effect the restriction of competition are prohibited. In its decision in the Carte Bancaire case, the Court of Justice clarified the by-object restriction, which had been described in the revised de minimis notice, which we will talk about later. The Court ruled that by-object concept is to be narrowly applicable only to conduct that itself reveals sufficient harm to competition that there is no need to examine their effects. Thus, contrary to some prior decisions of the Court of Justice, not all decisions, even if they include some pricing measures, can be presumed to harm competition, but only those that are clearly and sufficiently injurious to competition. All other agreements that do not have the object of restricting competition, the appreciable effect on competition needs to be assessed, taking into account the conditions in which the agreement operated and the economic context. This is an important decision that may well reduce to some extent, to some limited extent, obviously to be examined in the future, the extent to which Article 101 can, like Section 1 of the Sherman Act, be deemed to preclude per se certain kinds of pernicious concerted activity. It remains to be seen how that case will be determined in the future. I'm going to turn it over now to Sophie to talk about the technology transfer block exemption.
Thank you, Howard. Yes, the Commission last year adopted a revised technology transfer block exemption, which came into force on May 1st, 2014, and will remain in force for the next 12 years. As technology transfers are viewed generally as being pro-competitive, they are block exempted by way of a regulation, provided certain conditions are met. And along with the block exemption regulations, the Commission also issued a set of guidelines which provide further guidance on the application of the block exemption regulation, as well as the application of the EU competition law to technology transfer agreements that fall outside of the safe harbor. So the key features of the new regime is that it continues, first of all, to reflect that licensing is, in most cases, pro-competitive. Also, there is an interesting note in the guidelines is that while the patent pools are not covered by the regulation itself, there is a new guidance included in the guidelines where, under certain conditions, the creation and licensing from patent pools now benefit from a safe harbor. What the new regime says is that it takes a more prudent approach on clauses that could harm competition and innovation, and therefore certain types of clauses are no longer automatically exempted from antitrust rules, but have to be assessed on a case-by-case basis. So these include the clauses which allow the licensor to terminate a license in the event of a challenge of validity by the licensee. These termination clauses in non-exclusive licensing arrangements are excluded restrictions that fall outside the exemption and require individual assessment. Therefore, only termination clauses in exclusive licenses remain under the automatic block exemption. Also, clauses that force a licensee to license any improvements it makes to the licensed technology to the licensor on an exclusive basis are no longer exempted. The new block exemption regulations remove the distinction between severable and non-severable improvements. Accordingly, all exclusive ground-back clauses will not benefit from a safe harbor and will require an individual assessment. Another change is an important change concerns the restrictions on passive sales between licenses. Under the new block exemption regulation, all restrictions on passive sales between licenses are considered to be hardcore restrictions of competition. And so if they are included in the agreement, the whole agreement cannot benefit from the exemption. So this change brings the position on restrictions on passive sales in technology transfer agreements actually in line with the treatment of restrictions on resale of goods and services under the vertical agreements block exemption. There is an important and interesting note in the guideline that respect that they indicate that exceptionally such restrictions can be accepted and if they are objectively necessary for a licensee to penetrate a new market. So this is a significant change to in the new regime, that licensors now may be reluctant to offer licenses protection from passive sales unless they are confident that such protection is objectively necessary for the licensee to penetrate a new market, and if challenged, that such justification can be backed up by objective evidence. What does not change in the new regime is the list of hardcore restrictions relating to, among other things, price fixing, market sharing, output restrictions, but also the market share thresholds remain unchanged, meaning that the 20% combined market share for agreements between competitors still apply, as well as the 30% market share for agreements between non-competitors. So to conclude on that new block exemption regulation, there are some non-insignificant changes as they potentially withdraw the benefit of the safe harbor from certain agreements which were exempted from 101 under the previous regime, which are no longer exempted under the new regime. So it's a situation which may lead to some uncertainty for businesses, and they have until the end of April of this year to ensure that the agreements comply with the new block exemption regulation. Now I will say a few words about an important ruling which was delivered in June of last year under Article 102. It's the Intel ruling. It was delivered by the General Court of the EU, which dismissed in its entirety the appeal made by Intel of the Commission decisions finding the company a record fine of 1.6 billion euros for abuse of its dominant position. Intel had conditioned rebates to imported customers, and they are agreeing to source all or almost all of their supplies from Intel. And they had paid certain customers to halt, delay, or limit the launch of specific products. And so the court takes the view that when granted by a dominant undertaking, exclusive rebates are per se abusive and as such illegal when there is any objective justification for granting them. So the Commission was not required as the court to verify whether they had the effect of closing the market to Intel's competitors. The court clarifies that, takes the view that there is really no need to carry out what the Commission refers to as the as efficient competitor test. The court explained that it's not the amount of the rebates that matter, but it's the exclusivity that they impose, and significantly diminishing the ability of Intel's competitors to compete. Another interesting point in this ruling is that the court, in this analysis of rebates under 102, distinguishes three kinds of rebates. So the exclusive rebates, such as the one provided by Intel, which are presumed unlawful under EU law unless they are objectively justified. So it is therefore necessary to make an assessment in order to determine whether they have a potential effect of foreclosing competition. For the General Court, this strict approach of exclusive rebate for exclusive rebates introduced by the Hoffman-Lauer judgment is justified by the fact that they do not constitute a stricter sanction pricing practice, but the reward of exclusivity obligations. However, the Commission's also, the Court says that speaks as well about another types of rebates, which are the purely quantitative rebates, those linked to the volume of the purchases, and from the dominant company, and which are presumed to be lawful as long as they represent the efficiency gains and economy of scale achieved by the dominant undertaking. And between those two kinds of rebates, the court also talks about the third category of rebates, which are subject to in-depth analysis in the light of all relevant circumstances. Now I'd like to also just go over briefly other main EU decisions and rulings under Article 102 of the EU Treaty. The first one I would like to mention is a Commission decision in the Romanian Power Exchange case, where the company Opcom required the members of the spot electricity markets to have a Romanian VAT registration, and thus, on that basis, refusing to accept EU traders that were already registered for VAT in other member states, and therefore implying additional costs for those EU traders compared to the Romanian traders. So the Commission in that specific case was fined Opcom a fine of 1 million euros. Other interesting decisions here delivered by the Commission were in respect to the standardization patterns and fair, reasonable, and non-discriminatory front commitments. As you may know, the Commission started two investigations about 3 years ago after Motorola and Samsung both tried to enforce SAPs against Apple in Europe. And the key points of these decisions could be summarized as follows. First of all, seeking an injunction for a ECP holder is not necessarily anti-competitive, says the Commission. However, if the ECP holder has given a commitment to license on front terms during the startup setting and a potential licensee is willing to enter into a license on front terms, therefore seeking an injunction may be abusive under the EU competition rules. And also forcing an ECP licensee to waive its rights to challenge validity or infringement is not permitted. A licensee should remain entitled to challenge the validity and infringements of the ECPs. The third case I'd like to mention is the appeal of Telefonica of an EU decision by which the Commission found that Telefonica had abused of its dominant position on the Spanish broadband market by engaging in margin squeeze. In that specific case, the Commission had considered the infringement, which covered a period of 18 months, to be very serious and imposed a fine of 151.8 million on the company. So the decision was then appealed before the General Court, so the lower court before the EU, and ultimately before the highest court, the European Court of Justice, which entirely dismissed Telefonica's appeal. The judgment is interesting as it indicates that in order to establish that any practice is abusive, it must be shown that it has potential anti-competitive effects. Also, the effect does not necessarily have to be concrete. So in this case, the Commission demonstrated that there were potential anti-competitive effects that may have excluded competitors who were at least as efficient as Telefonica, which is therefore sufficient to establish that the practice of squeezing margins was abusive. And finally, I would like to say a few words about another decision which was taken in October of last year, and where the Commission imposed a fine of 38.8 million on Slovak Telecom for having pursued for a period of more than 5 years an abusive strategy to shut out competitors from the Slovak market for broadband services and imposing a margin squeeze on alternative operators. What is interesting here is also that it's the position taken by the Commission about the parent company that owns Slovak Telecom, so here Dutch Telecom, which hold in this case a 51% share of the Slovak Telecom's share and had a number also of special rights. And so the Commission considered Dutch Telecom to be jointly and severally liable for the conduct of its subsidiary. So under EU rules, as you may recall, parent companies exercising decisive influence are liable for antitrust infringement committed by their subsidiaries because they form a single undertaking under EU competition law. And as in this case, as Dutch Telecom had already been fined for a margin squeeze in broadband markets in Germany in 2003, the Commission also imposed an additional fine of 31 million on Dutch Telecom to ensure sufficient deterrence as well as to sanction its repeated abusive behavior. I'll turn it now to Howard.
Thank you, Sophie.
Excise Matrix.
Let's move now to merger enforcement in the EU, and we'll talk about it not only in terms of enforcement at the EU level pursuant to the merger control regulation, but also merger enforcement at the member states level. We'll compare from time to time merger enforcement in the EU with merger enforcement elsewhere, particularly in the United States under Hart-Scott-Rodino. There is in this area, as in most other areas, an abundance of substantive and procedural material that is available for study and review. The merger control regulation itself is accompanied by a wide number of notices and guidelines. In particular, is the notice on jurisdiction, as well as the guidelines for the definition of the relevant market, which is obviously in the merger context often the key issue in determining whether a particular merger is or isn't consistent with EU merger control law. Unlike mandatory merger control in the United States pursuant to the Hart-Scott-Rodino Act, where there is a relatively low threshold triggering enforcement of currently $75.9, soon to be $76.3 million. In the EU, to be subject to the EU merger control regulation, the size of the transactions and the turnover of the participants in the transactions is very substantially much larger. The basic principle is that mergers are subject to EU notification if the aggregate worldwide turnover of all parties exceeds 5 billion euros and the aggregate EU-wide turnover of each of the two parties to the transaction exceeds 250 million euros, unless each of the parties achieve more than two-thirds of its aggregate EU-wide turnover in one and the same member state. That last proviso is intended to protect the jurisdiction of the member state to regulate mergers in its territory that have a very significant impact. As you can appreciate, mergers and acquisitions that are of a substantial size often could trigger filing in a multitude of all of the 28 EU member states, and as an attempt to reduce the burden of making multiple applications, the merger control regulation also provides for a filing of smaller concentrations that have an impact in at least 3 member states, again with the proviso seeking to protect the jurisdiction of the member state merger control authorities. If a transaction meets these community dimension standards, a filing is mandatory, and the mandatory filing requirement imposes a global ban on closing until clearance is received. Foreign-to-foreign mergers have to be notified if they meet the requisite effects test within the European Union. There is, as I said, a very detailed and complex relationship between EU-level merger control and member state regulatory enforcement. It is possible under the merger control regulation for the Commission, at least in theory, to accede to a request from a member state to grant that member state the authority to investigate a merger. Similarly, there is a parallel provision which permits a party whose transaction does not involve a community dimension to request that the Commission assume jurisdiction and take jurisdiction from a number of member states that would otherwise have jurisdiction. We're going to talk about some statistics in the context of merger enforcement, as well as some key decisions and policy procedure developments. As I've indicated, there are a number of notices and guidelines. We have indicated where on the website the merger control materials can be found. There has been put into effect recently a simplified procedure. And I should say, by way of contrast with Hart-Scott in the United States, that the filing of a Hart-Scott-Rodino notification, while relatively burdensome in terms of the documentation that has to be filed and the industry statistics that have to be provided, pales by comparison to the very, very detailed, exceedingly detailed requirements of the so-called Form CO, which must be filed in connection with the EU merger control regulation. To reduce that burden, the Commission has recently introduced a simplified procedure to be used where the perceived competitive issues are smaller and more manageable than would be the case in a major full-blown Commission investigation. As I indicated, there are very, very fulsome notices and guidelines that should be reviewed in connection with any merger control regulation that you might wish to pursue, whether at EU level or indeed at member state level, since many of the principles that have been articulated in these notices and guidelines are followed as well at member state level. Finally, I would emphasize again the important issue of market definition and the notice on market definition, which is available on the website and which can often be the key to how the merger is assessed. Let's talk about some statistics. Over the last 4 years, there have been essentially around 300 notifications annually under the merger control regulation. Because of the size requirements for a community dimension, the number of notifications is substantially less than would be the case in the United States, where normally, depending upon the economic cycle in which we are in, there would be several thousand Hart-Scott-Rodino notifications each year. Before 2014, there were a small number of referrals back and forth between the Commission and the member states. Significantly, in 2014, there were 3 requests by member states that were rejected by the Commission. This reflects a tension between the member state authorities and the Commission, particularly with respect to certain member states, Germany in particular, that has long maintained a very rigorous and highly professional merger control authority, and which jealously guards their prerogatives. Perhaps like Hart-Scott, certainly proportionally, the vast majority of transactions that are notified are cleared in the first 30-day phase, whether with or without commitments to solve the problem because no problem was found, or that there was an identifiable problem that was easily solved through a commitment. In 2014, there were 8 Phase 2 investigations initiated. Phase 2 would be similar in terms of the scrutiny. That would be the case with respect to a Hart-Scott-Rodino second request. 8 out of 303 equals 2.6% of the notified transactions, and that is not particularly dissimilar from the level of second requests that occur in the United States. In terms of outcomes, I think the significant issues are that most of the investigations are cleared with commitments. But the most startling is that at least in 2014, there were no transactions that were deemed to be prohibited because they violated the EU merger control regulation. Let's talk about some important developments. The EU Commission imposed a 20 million euro fine on a company for implementing an acquisition prior to clearance. As I said at the outset, there is a mandatory global bar on closing. The level of the fine was the same as had been imposed several years ago on a Belgian company for doing the same thing. I think it reflects a growing trend in the EU that we certainly are seeing in the United States to take very seriously the mandatory bar on closing and to preserve through the fining power the ability of the EU to investigate and to investigate mergers within its jurisdiction. Having said that, the EU approved during 2014 a very, very large global merger in the cement industry. There were substantial divestiture requirements in the EU as well as in many jurisdictions around the world, and it would be very much the case that in this investigation, as in many investigations, there is a high level of cooperation between EU merger control authority, staff authority, as well as with merger control officials around the world. Under EU procedures, in completing and submitting the Form CO, the basic notification form, parties are required to state what their market shares are in various markets on a global EU and member state level. There was an investigation of the alleged understating of those market shares in the notification that came to rise during the more detailed investigation of the companies when internal documents which were discovered that were inconsistent with what had been notified. While the EU closed the investigation after the market share discrepancies had been explained, it points out the importance of the power of the Commission to impose penalties if parties to a notification misstate or understate or state incorrectly the competitive significance of the transaction. Most EU merger case outcomes focus on structural relief. However, in a recent banana deal, the merger was approved with conduct relief, in which the parties agreed to eliminate some exclusivity provisions in shipping contracts, and thus presumably reducing the level of vertical foreclosure and opening up the EU market to other possible suppliers. For the future, of particular importance is the question whether certain acquisitions of minority shares need to be notified. This is an issue that is not only the case in the European Union, but also is an issue that is developing in other jurisdictions, Brazil, for example. I'm going to turn it now over to Sophie to talk about EU distribution issues.
Thank you, Howard. Yes, in terms of distribution, the EU tends to take a more relaxed approach towards vertical agreements, which might restrict competition than the horizontal agreements. So the Commission grants automatic block exemption from the general prohibition of Article 101 by way of a regulation which sets out the circumstances in which the vertical agreements are automatically exempt. This block exemption regulation is complemented by a set of guidelines which describe the approach taken towards vertical agreements not covered by the block exemption regulation. Just before going to looking at some more specific issues regarding this regime, just let's highlight that in 2014 there were no EU cases involving vertical restraints. Enforcement action is largely handled at national level by the member states. The downside of national enforcement is that a great number of, as highlighted by a great number of national decisions and rulings, there are some non-insignificant differences in terms of interpretation of the law between the member states. Another important thing regarding vertical restraint is that it is an area where there are significant differences between the EU and the US approach, and therefore it requires careful consideration in order to avoid a number of potential serious problems. These differences are particularly significant in areas of exclusivity, but also resale price maintenance, minimum advertised pricing, internal sales restrictions, as we will see very shortly. And before we go over some of these differences and we call some important principles that apply in the EU law, just also would like to mention that the Commission also adopted last year a new notice on agreements of minor importance. These are agreements which do not appreciably restrict competition, and therefore the notice provides a safe harbor from the general EU prohibition on antitrust competitive agreements. What is the main change in this notice is that the application of the safe harbor presupposes that agreements do not contain any hardcore restrictions on competition, such as price fixing, market sharing, or any restrictions by object. So, as clarified in the new provisions, any agreements that have the object of restricting competition will now systematically be excluded from the safe harbor, even if the impact of those agreement is minor. So that's a major change that needs to be kept in mind. Now I'd like to just go over the main rules that apply in the EU, in particular with respect to exclusive and selective distributions, which are usually less favorable in the EU than in the US. As a general rule, suppliers may restrict active sales by distributors to a specific territory or customer group. However, absolute restrictions on passive sales are highly unlikely to be allowed. Online sales are considered as a passive form of selling, and any absolute prohibition on Internet sales is likely to be considered illegal in the EU. Restrictions to online selling in the context of a selective distribution system is only acceptable if they are equivalent to the criteria imposed on the sales from brick-and-mortar shops. So in other words, it doesn't mean that the criteria for online sales shall be identical to the one imposed for offline sales, but rather that any difference should be justified by the different nature of these two distribution modes. And justification for Internet restrictions remains subject to very strict review by the EU courts, as illustrated in the Pierre Fabre-Demo cosmetic ruling, where the court confirmed that an absolute ban on Internet sales in the context of selective distribution is a restriction by object unless that the ban can be objectively justified. In this next slide, now we go over also a list of non-exhaustive list of other Internet sales restrictions that cannot be exempted under the block exemption regulation, and it includes situations requiring the distributor to pay a higher price for products intended to be resold over the Internet than for products intended to be resold offline. Also, limitations on the proportion of overall sales made over the Internet, and situations where preventing customers located outside of an exclusive distributor's territory from viewing its websites and requiring the automatic rerouting to the other exclusive distributor's websites. So there are no specific guidance in the EU regime whether an exemption may still be possible outside the scope of the block exemption regulation for those kind of situations. So the companies with non-insignificant market shares have to be really careful in relation to any of their decisions in relation to Internet sales. I'll pass it on now to Herbert.
Thank you, Sophie. Let's talk about what for many has been a long and torturous journey that is not yet at its conclusion, but is further along than many thought would ever be the case. And that is that while for many years in the United States, since the passage of the Clayton Act, private damage actions, private treble damage actions that provide for attorney's fees have been permitted, as well as under Rule 23 of the Federal Rules of Civil Procedure, class actions. The ability of EU persons who have been injured by competition, by restrictive practices, has been very, very, very difficult to achieve. And as a result, the EU has been long seeking to develop a vehicle to facilitate the redress of those injuries. This past year, the EU adopted a directive on antitrust damages. As I mentioned at the outset, in terms of the kinds of legislation that the EU has, there are regulations, notices, guidelines, and directives. While a regulation, for example, would be automatically applicable throughout the EU and applicable to any person in the EU, a directive is by its terms, a direction, an order from the central EU authorities to the member state legislatures to adopt national legislation carrying out the terms of the directive, in this case, to provide for antitrust damage actions. The directive as well seeks to harmonize the very diverse and sometimes inconsistent procedural rules that exist among the member states. And the directive should facilitate the private actions with the introduction of a uniform system of disclosure, the uniform confirmation that cartelists are jointly and severally liable for the entire loss caused by the cartel, the establishment of a uniform statute of limitations, and other rules that are intended to facilitate the recovery of damages for antitrust injuries. There is as well an effort to promote greater access to information that is generated in the course of either commission or member state competition authorities for use in damage actions. And in addition, there is a continuing effort to create a viable and effective mechanism for collective redress, but that is something on which the final story has not yet been written. We're going to talk about some prospects for 2015, and I'll turn it back over to Sophie for the first several of those predictions that we have.
Thank you, Howard. Yes, fines for antitrust infringements in Europe are higher than ever, and therefore compliance continues to be crucial for every company active in Europe, and even more now that infringements of competition law can attract damage claims. So developing and maintaining a culture of competition ensures that a company can remain competitive and successful in the long term. Companies are therefore highly encouraged to ensure that they have an effective competition compliance program, where there may be some divergence in opinion as to whether a competition compliance program should run a reduction in an antitrust fine. It is clear that companies are expected to ensure effective compliance programs so that they will likely face more serious consequences in absence of such a program. Also, while competition authorities seek to harmonize their laws, it should be kept in mind that there remain substantive differences between U.S. and EU antitrust principles in a number of important areas. And where there are very few, if any, significant differences on issues involving cartel activities such as price fixing, market allocation, there are significant differences, as we've seen, in the area of vertical restraints. These differences are most powerful in particular in areas of exclusivity, resale price maintenance, but also minimum advertised pricing, internal sales restrictions, as we discussed, and price discrimination. I'll turn it now to
Thank you. Thank you, Sophie. In addition, in 2015, we see EU merger control enforcement continuing, probably at the same kinds of levels that it has seen in recent years, with a possible a wild card of increased uncertainty if the Commission adopts an amendment to the merger control regulation that would require the notification of minority interests in companies. As should be clear, not only will the global coordinated cartel war continue, but the EU has already in process a number of cartel investigations that will mature in 2015. Leniency and Leniency Plus, as well as the somewhat perverse settlement procedures, will continue to generate cases and continue to result in substantial settlements. Finally, what many might term a growth industry, there are tremendous opportunities, tremendous and growing opportunities in the EU for the pursuit of damage claims against companies, while there remain substantial policy and procedural hurdles. Those hurdles are increasingly being overcome. David, I think we'll turn it back over to you. I want to thank, on behalf of Sophie and myself, those who attended the conference, and we'll turn it back to David.
Thank you, Howard. So I would like to open this poll for our CLE credit. The 4-digit code for CLE credit is 1A1B. That is 1A1B. 1A as in Alpha, 1B as in Bravo. Please enter that code into the field that you see in the presentation window and click Submit. And again, if you are seeking Kansas, New York, or New Jersey CLE credit, in addition to answering the polling question, we will need you to complete the attorney affirmation form and return it, emailing it to myself. My email address is on the form. A copy of the form can be found on the resource list in the widget on the left-hand side of your screen. I'm going to leave this question up for about 30 more seconds, make sure we get everybody, and then we will proceed with the question and answer portion at the conclusion of this program. At this point, we'd like to invite any questions that our attendees may have. Please input them into the Q&A section, the widget on the left-hand side of your screen. All questions are private, and if you want them to be read aloud or shared with the audience, please just indicate so in your question. And we'll stick around for a couple more minutes here to answer those questions. And at the conclusion of the webinar, a survey will appear on the right-hand side of your screen. We request that you do take a few minutes to fill that survey out. It's important to us to know your thoughts, and it helps us shape our future programs and provide a better experience for all of our attendees. All right. In that case, we will, let's see here what we've got. We've got a couple questions. It does look like we did receive just one question. And Howard and Sophie, I'll defer to you on this one. But the question that was asked was, okay, thank you. The question that was asked was, is it possible to structure a rebate to a distributor which provides a different rebate depending on who the distributor sells to? And to clarify, meant to apply to distributors who sell to both end users and wholesalers rather than to one or the other.
Sophie, I will leave it to you to answer that, although it seems to me that this is, in a sense, a question that would involve both issues of a selective distribution as well as possible abuse of a dominant position, depending upon the position, the market position of the seller, as well as questions of price discrimination.
Mm-hmm. I fully agree that the position of the bodies involved is is an important aspect to take into consideration to study and see and take an approach in that respect whether that is can be allowed and exempted or not.
It certainly is permissible to have a selective distribution system that does, by definition, provide for restrictions that would operate under certain circumstances that, as Sophie has indicated, would need to be objectively justified. On the other hand, unlike the situation in the United States under the Robinson-Patman Act, where price discrimination is generally and widely prohibited if it is not particularly enforced, price discrimination per se under the EU law would be actionable only if it amounted to an abuse of a dominant position. Under EU law, that one would have to, of course, look at the laws of the various member states. I think that's our answer, David.
All right. Thank you, Howard. At this point, we are going to shut down the webinar. So again, I would like to thank all of our attendees for joining us and would request that at the conclusion here, you stay and do fill out the survey at the conclusion. As I mentioned, a copy of the slides and recording will be made available on our website shortly after conclusion here. Thank you all and have a pleasant day.